So welcome everybody today for our fourth GRAPHERGIA webinar, which is dedicated to intellectual property rights management and more especially to the licensing aspects and how to establish agreements among the partners who are co-creating results in an innovation project. So warm welcome to all the participants. And today I'm walking you through the session. I'm Mona Maril, the dissemination and communication leader from Australia, for those who don't know me. Nice to meet you all. And our key speaker today is Dr. Kostas Vavekis from a partner organization in GRAPHERGIA from Euplotia. He's a European patent attorney, and therefore he leads in our project the intellectual property rights management of the resulting innovation results. So therefore we propose this training session to the partners that are gathered here today, but also beyond to the sister projects who wanted to join, so welcome. We will have a question and answer session at the end of the presentation. So the idea is also to have something interactive. So if you have any doubts, anything you want to exchange with people who are also here as they are interested of the licensing, feel free to share. So warm welcome to all the sister projects together with the GRAPHERGIA team. So we have 6 projects presented here today from the biomedical, energy, and 2D materials of tomorrow sectors. So with that in mind, I would just like to let you know that as you've seen, we record the webinar because we would like to share it with the partners who cannot be here today, and you can also share it if you want to your partners. You can use the question and answer box throughout the session to write your questions, and we can take it at the end. And finally, we organize this session in the framework of GRAPHERGIA Hub, which is a platform for collaboration that we have put in place to exchange experiences and knowledge across the graphene flagship, but even beyond, to projects who are active in smart textiles, 2D materials of tomorrow, and lithium-ion battery projects. So this is the framework that we want to propose for today's session. And finally, because I know there are some new faces in today here, just a quick reminder of what GRAPHERGIA is about. So we are a research and innovation project running for 3.5 years. So we are a bit over the midterm of the project. And together with 11 partners across Europe, we develop an innovative pilot line applying graphene-based innovations on structural energy harvesting and storage devices. And we are especially focusing on application cases on smart textiles and next generation lithium battery electrodes. So that's what we do, that's the framework. And just warm welcome to all of you. I stop sharing my screen here and give the floor to our speaker. So thank you.
Hello, I would like to thank you also for the organization, also for being here. I'm going to present you the IP licensing, how if somebody has developed a new technology, can make money out of it by protecting and then by licensing to a licensee as a licensor, so and get some money back as royalties. I don't know, can you see my screen? Is it shared?
Not yet.
Okay. No. Right. Sorry, 1 minute to screen share.
No problem. Now it's okay, Kostas, you're sharing your screen. And now you can make it just full mode and even more full mode, and then it would be perfect. Perfect.
Okay. Excellent. So it will be a little bit more legal terms now, and I will try to give some emphasis on how somebody can license the technology mainly to the States, because I think this is our target group. So I'm going to speak with legal terms for common law and not so much our law, which is in Europe. So, what's a licensing agreement? There is a licensor who has developed some new technology and wants to transfer this technology to a licensee and get some money out of it. So a licensing agreement allocates some specific rights from the licensor to the licensee, as for example the time, and these rights have the parameters of time for how long we are transferring and allocating these rights to the licensee, the use, the territories for the Greece, for UK, for the States, exclusivity, and treatment of improvements. We will see this a little bit later, what do they mean. In exchange for these rights, the licensee provides consideration to the licensor, and this means actually money in the form of royalties, so which can be cash payments, services, or rights to improvement, even that the licensee will take the technology and make it better, and this is a type of a royalty. And all of this, we have to keep in mind that the ownership of the intellectual property remains with the licensor, who allows licensee to use it and gives him the permission to use it in exchange of the consideration of the royalties. What can we license? We can license patents, trade secrets, so something that we keep it as a secret and we have not patented or make it disclosed to the public, and we keep it as a secret. This means that we have NDAs with the person that or the company that we want to license it. We can earn royalties out of this. Trademarks, copyrights, sales and distribution, joint venture. I don't want to go more in details about this. And the purpose of a license agreement is, of course, to make some money, revenue, but also to exchange of technology, to reduce the risk, the legal rights risk, to increase our commercial capacity. For example, if I license my technology to another company and we make an agreement that they will produce new products or services and I will put my brand name also in that product, I increase my commercial capacity. And of course, data that are used for can be licensed, and they are very useful nowadays for different reasons. And the royalty rates, as we said, are payments by the licensee to another party, the licensor, for the use of the intellectual property, such as patents, trademarks, or copyright material. So there are a convention, the Georgia Pacific factors, which are 15 factors, which are used by courts, and these, especially in the United States, and these are used to determine a reasonable royalty rate in patent infringement cases. This was the outcome of the Georgia Pacific Corporation versus United States Plywood Corporation case in 1970, and this has allowed to create a framework for assessing the financial value of a patent. Let's see this briefly, these 15 factors, and then I will go to more legal stuff, what license agreements should include. So the 15 Georgia Pacific factors are, first of all, the royalty rates paid by the licensee for the use of other patents comparable to the patent invention. And that's reasonable because if somebody can use something else and not the patent that I need to get a license for this, the amount that I pay for something comparable that will do the same job for that patent, it defines its value. The nature and scope of the license, including if it's exclusive or non-exclusive. So it is different if, as a licensor, allows a licensee to use my technology, but only him, and I'm not allowed to give it to somebody else, or if I can give it to 10 licensees so they can sell it independently one by the other. It's important if the license establishes policy and marketing program to maintain the patent's value. So if I have a program that make it increases market penetration success as a licensor, this will mean that I will ask more money from the licensee. If we have commercial relationship between us, me, and the licensee, then of course can be different prices than if I license the technology to somebody, to a third party. Also, the effect of the patent invention on the profitability of the licensee, the portion of the profit that is allowed to get from the invention or the patent technology, the duration of the patent and the term of the license. We'll see what is the term of the license. So it's different if I license it for 1 year, it's different if I license it for 20 years. The profitability and the popularity of the technology, the advantages that the patent gives to the licensee over alternatives. We have already described this in different way. The nature of the patent technology and the market which it sells is different if it is for the pharmaceutical sector and is different if it is for the engineering sector. The license established market share and the role of the patent invention in the market. So if I have a patent, I will ask more money from somebody who is very successful and has a lot of money than somebody else who is not going to make a lot of profits. The potential for the patented invention to compete with the licensee's products, the licensor's willingness to license the patent. Let's not forget that sometimes the licensor does not want to license the patent. He wants to keep it by himself. Why? Because by this way, he has the monopoly of this technology. So if he makes a product, nobody else could copy or have this product. Of course, there is a competition law, and this prevents the licensor from doing this, especially for specific patents that they are used as a standard for developing a new technology. So the licensor has to license the patent. And this means that he will try to make higher royalties than if he was willing to license it. The rate at which the patent has been commercialized, it's different if we have a patent that earns money than something that somebody gets a license on this, but he will never succeed to make money. The licensee makes money out of it. And the effect of the infringement on the licensee's business. So if somebody copies this patent, what will happen in the licensee's business? Is he going to a lot of damages? So is he going to lose money? All of these are important for determining in a court the royalty for a patent. So I'm going now more deeply to the legal part. We have seen how the royalty rate is determined and several factors that they are affecting this royalty rate. Please stop and ask me any questions that you have if you want to ask anything. So now, a license agreement is based on the contract law because it's a contract. And so contract principles apply. There is an offer and an acceptance. As you remember, we have talked about consideration. Consideration are the obligations between the parties to a contract. So the royalty fees, for example. And there should be an intention to form a legal relationship. It is not an obligation. If we have a contract, the parties should agree and they intend to have this kind of relationship. There should be a mirror image rule. What does it mean? I, as a licensor, offer an agreement or a contractual agreement to a licensee. He might accept. If he accepts, then we have a contract. If he does not accept this offer, then we don't change the offer. He creates a new offer and sends it back to me. So this counter offer is a new offer, which I have to accept or reject. And of course, contracts must be in writing. It's not always this, but if it's in writing, of course, it is valid, enforceable, and more difficult disputable. What are the parties and what is their legal capacity? So who is bound and who can be sued? let's say that I work in a university and I have developed a new patent. I am the inventor of the patent, and the university is the applicant. And I'm going to a big company and say, okay, do you want to license my patent? And I sign a contractual agreement with with the licensee company. This is not valid because I don't have the capacity to sign that transfer of this license agreement. Because the applicant is a university and I'm the inventor, and the inventor doesn't have the right to file such a claim. So, by having established the parties, this can prevent disputes about authority. And as I already mentioned, parties should have the legal personality and capacity to sign. And if the agreements are signed without this authority, they may be void or unenforceable. In a license agreement, we have to include several parts: recitals, definitions, grant, royalty, reports and payments, best efforts, sublicensing, ownership of IP, enforcement of IP rights, assignability and transferability, representations and warranties, indemnification, term and termination, and confidentiality. And some other parts also: releases for past infringement, most favored nations, improvements, grantbacks and clawbacks, integration and modification, arbitration, governing law, severability, force majeure, notices, form selection, and counterparts. Let's see the most important of this one by one and with examples. This is what I'm going to present you today, Axel. Recitals provide context and intent. And you will understand what do I mean when I give some examples. For example, whereas licensor owns certain intellectual property rights in and to the technology described herein, or whereas licensee desires to obtain a license to use such intellectual property under the terms of this agreement. So it gives the context of this. This clause gives the context of the agreement. Definitions. Let's give an example. Licensed products means any product developed, manufactured, or sold by licensee that incorporates or relies upon the licensed technology. So definitions are at the beginning of a contract, and it has a very important role to play concerning eliminating ambiguity and increasing the clarity, because we give the exact meaning of the key terms that they are appearing later in the agreement. We ensure consistency because the same term is defined and is called with the same wording, and we don't change this wording inside the contract, so to create ambiguity. This allows us to reduce disputes, to improve readability, and introduce brevity, because by avoiding to explain each time the meaning of some words can make the agreement shorter. And of course, we can help courts to rely on the defined terms, interpret and enforce the agreement. The most important part is the grant, because here we define the rights that we give as a licensor to whom, to licensing, and how they can be used. So what should be covered is what's being licensed. For example, is software, is a patent, is a trademark, is an art content. The scope, how the licensing may be used. So for a patent, for example, he might be allowed to make it, to sell it, to modify it, to distribute it. Is it an exclusive, non-exclusive license? The territory in which areas we are allowed we are allowing the licensee to use this technology and to sell or to make and to modify this technology, and the duration, how many years. And it's very important also, when we define the scope in the grant, not to exceed the one that it is included in the right. What do I mean? For example, a patent has a life maximum of 20 years. We cannot say in a grant agreement that allowing you, give you the license to use this patent for 30 years, because we don't have the patent doesn't have this right. So Or if the patent is, the remaining life of the patent is 5 years, you cannot say we are giving you the license to use this patent for 8 years. So you have to take care to include the correct rights that they are inside this licensed product. This is what I have said. The rights must correspond to the legal rights of the IP. Also, the type of rights. Rights for a patent is make, use, sell, and import. But a patent based on that patent, a product based on that patent, for example. And for copyrights, we are allowed to produce, perform, make derivative works. An example clause. Licensor hereby grants to licensee a non-exclusive, non-transferable license to use the licensed technology solely in accordance with the terms of this agreement. Now, okay, we have seen what's the grant, what we are going to grant, but what payments are going to receive? They can be in the form of a lump sum, per unit, a royalty fee per unit, a percentage, and can be cash, in-kind services, or can be non-cash consideration, for example, to participate in the company as an equity holder. And also, we should take care about foreign currency issues because we might agree something today and the exchange rates to change so much that will have totally different value in a few years. The royalty base is the measure against which the royalty payment amount is calculated. Also, we should agree with the frequency of payments, if it's deferred payment, so if it is at the beginning, at the end, in one go, or how the payment is going to conclude it. And also, we should take care about tax issues, especially because we are going to, the agreement will be between different countries. We should consider tax issues important, difficult, and the best one, my advice is to create a draft with a hypothetical amounts, or for example, that this item is sold in so many items, or the revenues will be that amount. So let's calculate what the amounts that I'm going to get as a royalty will be, with including all these things like currency issues and tax issues. As I already mentioned, it could be one-time payment, lump sum, upfront payment. Is it non-refundable? For example, if it doesn't work, the technology, or if I have no sales, what's happening? If I have paid a lot upfront payment, can I get some money back? Is there a periodic royalty? Is it a hybrid form? And of course, the royal base, as we already seen, this is defined by different ways. For example, the example at the beginning, I have shown you how the courts are deciding it. An example clause could be licensee shall pay licensor a royalty equal to 5% of net sales or licensed products. Licensee shall provide quarterly royalty reports within 30 days following the end of each calendar quarter. So not only is it important to include the royal base and what somebody will get out of it, but we should include in the agreement clauses that we can ways that we can check the licensee through reports, through whatever, how many, what is the amount that they own us as a royalty, and also to have a clause that we are allowed to check their financial data, and to be able to do examination with an accountant to see he says us the truth that they have so many sales or so much profit. So we should be able to verify these numbers and to feel safe that we are going to receive the correct amount of money as royalties. What's best efforts, commercially reasonable efforts? We have clauses that impose a performance standard without guaranteeing results. This is used when we talk about future outcomes that depends on market conditions. For example, licensees shall use commercially reasonable efforts to develop, market, and sell the licensed products within the territory. Actually, this doesn't have so strength in a court because it doesn't have something numerical, and it is more depending on the market to prove that the market is good or bad or whatever. Sublicense. If the licensor allows the licensee to sublicense, so to become again a licensor to a third party, to sublicense to a third party. So in general, this is prohibited, and unauthorized sublicense may be invalid. A licensee shall not grant sublicense without the prior written consent of licensor, which shall not be unreasonably withheld. Similar is the assignability and transferability because we restrict who may benefit from the license and protects the licensor from unintended counterparty. So the licensee, if he transfers the license to a third party, the licensor should know about this and should agree or not. Licensee may not assign or transfer this agreement in whole or in part without the prior written consent of licensor, except in connection with a merger or sale of substantially all assets. Up to now, is it clear? Do you have any question? Because can you hear me?
Yes, we can hear you, Kostas. Thank you.
Okay, thank you, because I can't hear anything, so I'm afraid of the reactions.
No, everything is clear. Thank you.
Thank you very much. Okay, so ownership of IPs. Okay, this is also very important. We have already discussed about who is the owner and who has the parties. But this allocates control and costs of infringement actions and clarifies who has standing to sue. So if I am the licensor and I license a patent to a licensee, and there is infringement, somebody copies this patent. Who has the right and who should go to a court against this infringer? Normally, the rights, title, and interest remains to the licensor, and he has the obligation of this, but we will see this later also. Improvements, grant backs, and clawbacks. This, you can see it also in an example. It means when we have an improvement of the innovation, who gets the ownership of this improvement? Because I am, as a licensor, gives my technology to a licensee. The licensee makes it much, much better. So grant backs preserve the licensor's control for this improvement, so he can use it actually, while clawbacks prevent permanent loss of strategic developments. And let's see it in the example. All improvements to the licensed technology developed by licensee shall be promptly disclosed to licensor. So the licensor should know what's going on. Licensee hereby grants licensor a non-exclusive royalty-free license to use such improvements. In the event this agreement is terminated, all rights in such improvements shall revert to licensor. This is not an obligation that will work like that, but it is food for thought. When we make an agreement, we should always consider the improvements, who will own the improvements, and in what degree the licensor can use them without paying royalties. Most favored nations rights. What does this mean? Actually protects the licensee against competitive disadvantage by ensuring parity. And so they restrict the license of future freedom to negotiate. I will see it and we will understand this by the example. Licensor represents that the financial and commercial terms granted to the licensee are no less favorable than those granted to any similarly situated licensee. In the event licensor grants more favorable terms to any third party, such terms shall automatically apply to licensee. This means that I cannot make an agreement with part A. I will say, okay, I will license my technology for 5% royalty fee and go to somebody else and I'll ask 3%. And with such a clause inside the agreement, we can be protected that the licensor will not give another licensee much lower, much better terms than to us. Okay, these are normally at the end, but doesn't mind. Arbitration. Because we are talking about cores in different countries, for example, if from someone from Europe and someone from the States or from China, we are licensing our product to our technology to a third party. So there are one difficulty is the government law, which law is going to be valid. If I am from Greece, I'm licensing a technology to a company from the States. Should we use the law of Greece or the law of the state in a Greek court or in the state court, in Greek language or in English? So these are some considerations. There are some treaties, European international treaties arranging this, but sometimes it's not so clear, and especially if countries are not participating in these agreements. And also there is the possibility of arbitration. Arbitration means we replace court litigation with a private dispute resolution, so and determine procedural rules, confidentiality, enforcement of awards. So we put one or a committee of one person, of 3 persons, 5 persons from a specific arbitration unit, and they will decide about our dispute, and their decision will be enforceable to us. So we can use as a clause, any dispute arising out of relating to this agreement shall be finally resolved by binding arbitration under the rules of the International Chamber of Commerce conducted in English, for example. This saves a lot of costs and disputes and time if we go than going to courts, but normally arbitration is very expensive compared to a first instance court. If we go to further instances, it's more expensive, maybe the courts, but it's faster, and there is no second instance. If there is a decision from arbitration, we cannot go to a second instance or third instance court to change this. So these are our limitations of arbitration. Now we are going to another group of provisions, risk-shifting provisions, which determine who bears the legal and financial consequences if the agreement turns out that does not work because of some assumptions that they were false. So this means we are going to talk about a little bit about representations, warranties, disclaimers, limitations of liability, and indemnities. My main thing here is warranties versus indemnities. We'll see this detail. So representations and warranties. This allocates risk to the licensor or to the licensee, and gives a responsibility regardless of intent or negligence. And we'll see through the example. Licensor represents and warrants that it owns or controls all intellectual property rights necessary to grant the license set forth in this agreement, and that licensee's authorized use of the licensed technology will not infringe any third-party intellectual property rights. So, if I am the licensor, I gives my technology and receive royalties for this to the licensee, but it is not, it doesn't have freedom to operate. And if by using the licensee, using this technology, it infringes other parties, then who bears this cost and this not allowance? We have different types of warranties. One is an express warranty, and is an affirmatively stated and contractually enforceable on its own terms. It's an explicit warranty. So it's state that licensor expressly warrants that the licensed software shall substantially conform to the specifications set, whatever. There are the implicit warranties. That means that a national law, for example, in the United States, may imply warranties for specific transactions. But we can add in the agreement disclaimers of implied warranties that we eliminate the implied warranties to the extent permitted by law and to shift risk to the licensee. An example, except as expressly set forth herein, the licensed technology is provided as is, and licensor disclaims all implied warranties, including any implied warranties of merchantability, fitness for particular purpose, and non-infringement. So now, by this way, although there is an implied warranty as a general rule in one country, we try to say that the technologies provide as is, and we move this the cost or the failure because of non-infringement to the other party. There are also the imputed warranties, which acknowledges mandatory legal protections and avoids invalidating the entire agreement due to overbroad disclaimers. Now we are trying to overcome the problem with disclaimers. Nothing in this agreement shall exclude or limit any warranty or liability that may not be excluded under applicable law. So here we say that the law is above and we should use these warrants that with a disclaimer could have avoided. So this is a matter of negotiation and what we'll include in the contractual agreement. Who actually will get the problem when there is a problem with the technology to be licensed, if there is infringement, if the technology infringes somebody else's technology. Of course, there is caps on liability, which means that we set a maximum exposure and makes the risk financially predictable. So, license total cumulative liability under this agreement shall not exceed the total amount paid by licensee to licensor in the 12 months preceding the claim. So, we put the maximum exposure that we can have as a licensor. And we can, by this way, we can certify that we are going to give more money back than what we have entered, what we have gained from the royalty. And I don't want to give emphasis on this, but there are the exculpatory clause. It's a contractual provision which one party limits or eliminates its liability for certain times of omissions that they are coming out as negligence or product liability. If the product doesn't work, if something is wrong, then we can avoid liability. And we come now to indemnification. Indemnification is something like the warranty, but it has a different meaning that a warranty is a contractual promise about the accuracy of the fact. But the indemnification is the contractual obligation to defend and compensate to the other party for losses arising from specific claims, especially third-party claims. So, how to compensate, to give money to the third party because of these problems that they have been identified. For example, infringement. And here I'll give you an example. Licensor shall indemnify, defend, and hold harmless licensee, its affiliates, officers, directors, employees, and agents from and against any and all third-party claims, demands, actions, proceedings arising out of or alleging that the technology transfer, when used in accordance with this agreement, infringes or misappropriates any patent, copyright, trademark, or trade secret, and shall pay all damages, settlements, and reasonable attorney fees finally awarded or agreed to in settlement. So, by this way, we specify who will get the cost actually for the infringement or for what is not expected. In the warranty, we saw who has the blame. Now, what will cost as a blame? So, we have several questions. One question is who is going to pay whom? The obligation runs from the licensor to the licensee, from the licensee to the licensor, or operating on a mutual basis. So, which party ultimately bears the risk of third-party claims? For example, if I am the licensor and I license something to licensee, and this is infringing a patent, I have the blame. I have to pay money. If the licensee uses technology in a wrong way, something that makes and it is not agreed for that use, then he has to pay me back money to the licensor. So it depends on the indemnification can put the obligation from one to the other party. A second consideration is the scope of the protected parties, because the indemnity may be limited to the licensee alone or extend to additional beneficiaries, such as the licensee's affiliates, customers, distributors, retailers, or end users. For example, I am licensing a technology to a licensee who is producing a product, and this product, he sells it to a company who puts it in the market. The damage will be to the licensee and to this company who sells the final product in the market. So the licensor, whom should pay? Also, the final, if there is some money that they have to be paid, we have to, from with the indemnification, we have to, there is a possibility to include not only the cost over the judgment, but also the cost for the defense, such as the attorney fees, litigation expenses, settlements, and other liabilities. And let's not forget that if we go to a patent dispute, in the state, for example, can be up to several millions of dollars. In UK, even to 1 million easily. In Europe, is a little lower. So, indemnify, defend, and hold harmless obligates the licensor to pay losses, but also to pay legal defense. Third-party claims is only for losses from outsiders, especially for IP licensing. If we use the term when used in accordance with this agreement, we narrow the licensee's exposure so it does not cover misuse by the licensee, because the licensee might use it in different ways that we have agreed. Infringes or misappropriates, ties the indemnity to recognized IP violations. What is the patents that we have violated? What should we pay for this? And of course, damages, settlements, and reasonable attorney's fees means all the scope of financial responsibility. And damages can be huge also, because it's what a company does not gain because the actions with the other company. There are other topics that we should consider. For example, when the patent years are finished, the bankruptcy, as we already mentioned, tax, competition, I have already mentioned, cross-border issues in licensing, because in different countries you have different rules and different cultures, currency exchange, and also it's very important the defense sector, because defense sector brings a lot of problems and legal barriers to license a technology from one country to another, especially if it's for that sector. And so it has to be explained in that it is not affecting the defense of one country. I'm going a little bit faster because I don't think we have plenty of time. So, okay, we have discussed with another company. We are the licensor. We have identified licensee. We have discussed. We say, okay, we will agree for licensing this technology or whatever. We need initially to create a term sheet where we will put all our agreement inside. It is not a legal document. It is not binding yet, because when it will become a contract, it's binding. So a term sheet for a license agreement is a short, non-binding document that captures the commercial deal points before lawyers draft the full contract. So it's an initial agreement. So everything we have discussed, we can put it in a first form, and then this can become a contract. But what this should include? The parties. The license subject matter, we have already discussed about this. The type of license, scope of use, territory, terms, financial terms, what will gain, if it's allowed sub-licensing, ownership of IP, who will be the owner, what will happen with the improvements, enforcement, indemnification, as we already have explained, termination rights, how we can terminate this agreement, the governing law, which country, which system, legal system, which course, confidentiality, and binding and non-binding status, if it is binding or if the contract will be the binding one. And when we close the deal, we have to review, of course, all terms. We have to consist consistently. when we have the contract with the term sheet and the final negotiations. Always we have to compare the signed agreement against the final signature version. To have a strategic alignment of what we do and what we try to achieve with this licensing agreement, and to assign internal ownership and responsibility of who will follow this license agreement, that the other party is correct and is giving what it owns to us. We have to implement reporting, and of course to do ongoing review to ensure that the agreement is fulfilled and it remains consistent with the intended purpose. And two more things that you can find the contractual agreement word: the parallel evidence rule, which means that when the parties have made an agreement, a written agreement, evidence of prior oral settlements cannot be used to change or contradict with the written agreement. So, okay, we make an agreement, we have agreed these things, we make a contract, but the previous one of the parties discovers that we have agreed something else and it was not clear, and we cannot change this agreement after it was signed as a contract. So this has to be included. We need an integration clause which states that the written contract supersedes all prior negotiations, drafts, and understandings. And the final, the contra proferentem, which tries to avoid contractual ambiguities. Sometimes we have one in the contract, several parts creating ambiguity, or one part is different than the other part, and these are interpreted differently. And we have to create a standardized contract in order to be protected by these situations. And normally, the party who has prepared the contract has the liability if there is an ambiguity. Thank you very much. This was please any questions if you have.
Yes, thank you, Kostas. Maybe you can stop sharing so we can see each other and give the floor to people who want to ask questions. But already, I think it's quite interesting to see at this really theoretical scale how much work it actually takes to put in place licensing agreements. And if we put it to the context of European research projects, where we are still in the early stages of innovation and where we start by maybe initial proofs of concept, and we try to take it to the demonstration phase. So we will talk about maybe technological readiness level 5. So we are only at the beginning of maybe starting to identify where we can actually put patents, where we can put trademarks and so on. So maybe my first question, and then we can take questions, I think people have some here, is that, so in this framework of European research projects, once we have identified really the key exploitable results of the project and what the partners are actually developing together, that can be methodologies, they can be technologies, they can be components, so different kind of things, right? What is the ideal time where partners should also try to start handle the licensing of those results? Is it something that goes along with when they start managing maybe the trademarks or the patenting of those results? So is it something that is actually feasible during a lifetime of a 3-year project, or is that something that should be foreseen beyond it?
In my opinion, we cannot say that it is from the first day or the last day of the project or afterwards. It is a matter of when there is a market need and somebody willing to buy the technology. Even if it is not proved the technology, it is at the beginning, if there is a huge market for this and companies are interested in buying that technology or licensing that technology. You can see this from patents, even similar patents that they're trying to solve the same things. And we see that they change hands easily. They are licensed, they are sold, whatever. Then this means that there is huge commercial interest. And if we have a patent, especially, or even a trade secret, can be licensed, can be sold, and it is depending on the stage that we are, the price will be different. For example, if we sell something that it's at the initial stage, there is a patent or a patent application, will not be yet a patent, or even a trade secret, then we agree with the company will license it with less money, but we have less, but with higher risk. If it's at a later stage, if it is an MVP, if there is a product or whatever, then of course the market will be much higher. The company, the research organization, whatever, has put much more money in that. So they have developed a product. So they have developed the technology more. And then when they licensing this technology, it will be much more costly, because the other party will take something ready. They don't have to do work, or they don't have to so much risk. So depending on the stage, it always can be licensed or can be sold. But depending on the stage and the maturity of the market, the money, the royalty fees will change.
Excellent.
I remember a big company bought a patent for a pharmaceutical molecule, an active ingredient, and they were saying, we have bought that amount of millions. If we have bought this when they have created the patent at the beginning from that university, we could have bought it less than 100,000 euros. But now we have bought so many millions because they have discovered the value of these molecules.
Okay, very good example. Evie, do you want to take the mic?
Yes, thank you. So I have one question I had. Sorry, I'm shouting. You said that licensing is not only about patents, it can be about trademarks, about computer programs, or about know-how. I know that computer programs like simulations, they can be licensed, but know-how and trade secrets, as you just mentioned now, how can they be protected?
Know-how, it is difficult. But trade secret, yes, it can be protected. It can be, a trade secret has a legal form. If it is something that it has value, and we protect it by enough means. For example, we put passwords, we don't disclose to the people, and it's not known to the public, then it can be protected legally. So if somebody tries to copy it illegally, he will have to pay fines or to pay damages.
But then this cannot be a scientific result. It has to be.
No, of course, it can be a scientific result. And then when we have this trade secret, so a new technology, and we want to sell it to somebody else or to license somebody else, we can make an agreement that he will keep it also as a secret. And for this amount of time, also we are obliged, and we are going to license to use it to make something. And I will give you a more specific example. Let's say that we create a new molecule, a new pharmaceutical molecule, a new ingredient for cancer. If this ingredient, if this active compound can be discovered by reverse engineering, by chromatography, by mass spec, by whatever, and another company can identify this molecule and copy it, then the only way to do it is creating a patent. If there is no way that the other company can identify this molecule, or for example, if it's a method and the other company cannot understand how we create this method to create something, a new pharmaceutical composition, and then why to make a patent? We keep it as a trade secret, and we licensing or we sell it as a trade secret. It has the same strength as a legal term because it is recognized as a legal term. We keep it secret. They keep it secret through NDAs, and so we can license it. And for me, in my opinion, better not to make a patent because it is cheaper and because you don't have to go to all the countries and start running again with in different cons for infringers. Nobody can discover how you do it. So keep it in your drawer, keep it secret, and create the results. I don't know if it's clear or not.
Yes, quite. Thank you. Very interesting, actually.
Is there anybody else who would like to share a question, share a comment, an experience?
I hope it was not too legal and too boring.
Okay, So if we don't have any other questions for the moment, what we will do is that we will share with all the participants the recording and also the slides. So you can go back there to check what was said. And other than that, we were perfectly in time. And I would like to thank everybody for being here today, and especially Kostas. Thank you for sharing your wisdom in the
Thank you.
very difficult field for those who are not so familiar with the topic. And we will certainly propose more sessions on this very topic of intellectual property rights. So of course you will be then all invited again before the ending of GRAPHERGIA. So thank you everybody, and see you soon.